Good evening, all. Even in these difficult times of lockdown, Nasik Bar Association has decided to utilize this time creatively and started and took initiative to arrange the webinars on different legal topics. Till date, Nasik Bar Association has arranged 34 webinars on different topics of eminent dignitaries in the field of law. Likewise, today we have with us one such dignitary, Mr. Durai Karunakaran. Now I would like to invite Mr. Nilkant Iyer to introduce today's special guest for today's webinar. Mr. Nilkantji.
Thank you, Mr. Gaidani. I hope I'm audible to everyone.
Yeah, you just adjust your height.
I logged in from a different system, so that is the only height. It is a fixed camera.
Okay, no problem. Yes.
Please proceed.
So although I'm sitting on a lower sitting.
Yes. Okay. No issue.
Okay. Good evening, everyone. Am I audible?
Yeah.
Yes.
It is a great honor and privilege to introduce and welcome Honorable Shri Duraikannu Karunakaran sir, the former Chief Justice of the Supreme Court of Seychelles, Republic of Seychelles, who is also a recipient of the Pravasi Bharatiya Samman Award, the highest award that can be given for any non-resident Indian. He is also endowed with the Tamil Crown Jewel Award. I welcome sir to this Nasik Bar Association webinar session. Very kind of you to grace this occasion and spend some time with us. I take this opportunity to also welcome all the respected office bearers of the Nasik Bar Association, President Shri Nitin Thakureji, former chairman and member of the Bar Council of Maharashtra and Goa, Shri Jayan Jai Bhaveji and Shri Avinash Bhideji. I also take this opportunity to welcome Shri Rajiv Patilji and also welcome all brother and sister lawyers as well as law students from Maharashtra. I've been very fortunate to be introduced to Lordship by none other than a very greatly respected friend, philosopher and guide, our most beloved former Minister of External Affairs of India, late Honorable Srimati Sushma Swaraj ji. And I'm humbled to speak about Lordship's achievements. All I can say is he has developed a very well-rounded and well-exposed professional profile by acquiring education possibly from all, or rather as many jurisdictions as possible that one can. Justice Karunakaran holds a master's degree in political science as well as general sciences. He also holds the Bachelor of Laws, the LLB, and the Bachelor of General Laws, the BGL, from the University of Madras. He also holds an impressive list of diplomas and certificate programs from various countries where he has spent time. He holds a diploma in international laws from the United Kingdom, a diploma in advanced leadership and management from Mexico, a diploma in general jurisdiction from the United States of America. He is certified and qualified in explosives with regard to prevention of terrorism law from the New Mexico Technology University. He is certified in the critical incident management from the Criminal Justice Center, Texas, United States, as well as computer skills from the Eastern New Mexico University, United States. He is also certified in anti-money laundering laws and compliance and risk management laws from the Channel Islands. Justice Karunakaran has been in active practice of law since the past 40 plus years. In 1981, he started off as an advocate at the Madras High Court and then qualified as a barrister and attorney at law of the Supreme Court of the Republic of Seychelles in 1983. In 1981, after starting as a government pleader, assistant public prosecutor and state counsel at the Madras High Court, he started representing the interest of a lot of financial institutions, insurance companies, construction companies, as well as many other commercial enterprises in the Republic of Seychelles. Thereafter, in 1983, he joined the Victoria Chambers of Francis Rachel Law Center, a law firm of repute in Seychelles, as their senior counsel. In 1988, Lordship was appointed as the legal counsel of Seychelles Housing Development Corporation. In 1990, he was appointed as a magistrate for the Republic of Seychelles and thereafter as a senior magistrate. In 1991, he was appointed as the President Court Marshal for the Seychelles People's Defense Force. Along with this responsibility, he was also appointed as the chairman of the Tenants' Right Appellate Tribunal of Seychelles. Going on, recognizing his extraordinary talent, he was also appointed as the chairman of the Rent Control Board. In the same year, he was appointed as the president of the Juvenile Courts of Seychelles. Justice Durai Karnakaran has largely contributed to developing the legal system of the Republic of Seychelles to the stage it is today, after getting independence from the United Kingdom. He founded the Bar Association of Seychelles. In 1998, he also founded the Family Law Tribunal of Seychelles and was appointed the first chairman of the institution. He has also served as the chairman of Seychelles Revenue Tribunal. In 1999, he was appointed as the judge of the Supreme Court of Seychelles, and thereafter, serving in this capacity, Lordship has also served as the Chief Justice of Seychelles. Although he has retired now, he is actively involved in advisory and consultancy matters. More so, he is a very leading brand ambassador to attract investments to the country of the 115 archipelago. Sir's vast experience in the field of law has touched upon all areas of practice we can possibly imagine of. While Sir is a member of the National Commission for Children Protection, Republic of Seychelles, and he is also currently a life member of the Commonwealth Magistrates and Judges Association, London. In his professional career, Lordship has also presented many research papers in the field of law, spanning more than 40 years across various forums around the world, and has also been honored by the government of USA for this exemplary judicial service. We are honored to hear you, Sir. Justice Durai Karnakaranji, please. Thank you.
Thank you, Mr. Nilkanth, and very much thankful for your kind words. I hope I can start my lecture now.
Please,
can
sir.
you hear me clearly? Thank you.
Yes, sir. Yes.
Distinguished President Mr. Thackeray and learned members of the Nashik Bar Association, the law students, the organizer of this event, Mr. Nilkanth Aher, dear participants, ladies and gentlemen, greetings from the Republic of Seychelles. Namaste. I am so honored to be invited to deliver a lecture on the subject, the constitutional vision for glorious Bharat. I am so grateful to all of you for having given me the privilege, time, and opportunity to share some of my thoughts with you on this subject. I would like to begin by evoking the preamble of our Constitution, which remains as a constant reminder of our vision for a glorious Bharat. It is articulated thus: we, the people of India, having solemnly resolved to constitute India into a sovereign, a socialist, a secular, democratic republic, and to secure to all its citizens justice, a social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. The vision for glorious Bharat was inextricably intertwined in our constitution nearly 70 years ago, when differing political and social thoughts converged, reconciled, and social thoughts were tuned in consonance under the wise leadership of the great legal mind, Dr. Baba Sahib Ambedkar. The Constitution of India was thus born, not of a political revolution, but of a mental revolution triggered by great minds of our leaders and intellectuals of that time, who, after meticulously analyzing all socio-political and economic conditions and territorial status which existed then in India, and molded the Constitution accordingly. They provided for all contingencies which they could foresee what humanly possible at that point in time, but none can obviously go beyond with the foresight of a prophet and provide for all with a divine precision and perfection. Finally, with much intellectual labor, it was enacted, adopted with the inevitable transitional or temporary provisions such as Article 370, and delivered to ourselves through our Constituent Assembly. Incidentally, the Constitution being an organic living document, it is incumbent on us to nurture it continuously, but preserving its basic structure and treasure it for the generations to come. At the same time, the framers of the Constitution obviously could not have incorporated temporary provisions therein with an intent to keep them permanent and remain as sacrosanct forever on the shiny pages of the Constitution, since that would defeat the very purpose, rationality, and constitutional wisdom of the makers of it. 70 years ago, we began our voyage, a voyage of political exploration, entering Swaraj, a Raj of our own without any epithet, vituperative or otherwise. We embarked on our Constitution, setting sail on the ocean to reach our promised land with an adorable dream of glorious Bharat. A Bharat dream, if I may call it that, a dream of a modern, sovereign, socialist, secular, democratic republic to proudly stand tall amongst the comity of nations as Bharat Mata, gracefully unified from Kashmir to Kanyakumari, and invincibly strong from top to toe, in which life was better, richer, and fuller for every son and daughter of great Bharat without discrimination, whether based on race, color, caste, religion, creed, sexual orientation, regionalism, or linguicism, or economic status, or political ideology, with equality of opportunity to enjoy freedom, justice, welfare, fraternity, prosperity, peace, and unity. Our dream was not based on an illusion, but on a vision that sprouted from our glorious past and our resilience to resurrect and go beyond the obvious to see the invisible and touch the future for posterity. Bharat dream was not about problem solving, but the preemption and prevention of problems which had invaded, divided, and eclipsed our past with the darkness for many centuries. We thus decided to rewrite our political destiny. We regained our unity, territorial integrity. We had to pick up the broken pieces from the past, including its inevitable Greek branded name India, after nearly 1,000 shattering years of invasions, divisions, killings, lootings, and political enslavements. Bharat Dream has now taken shape with roots that give it a strong hold on ground realities and wings that give it the ability to fly and reach new heights. It is beautifully animated in our preamble of our Constitution, which is the key to reaching into the minds of the framers of it. They envisioned that we, as one people and one nation, create a classless and just society for all. As the largest democracy on this planet, comprising more than 1/6 of the world population, we serve as a role model for a harmonious, multiracial, multi-religious, multicultural, multi-ethnic, and multilinguistic society. The framers of our Constitution recognized the inherent dignity, equality, and inalienable rights of all members of human family and oneness of humanity, as deep-rooted in our ancient philosophy, Vasudeva Kudumbakam, and in Tamil, Yadum Ur Yavarum Kelir. However, it is not an easy task to navigate and sail through the Indian Ocean of turbulent politics and realize our constitutional goals to reach the promised land within a time frame. Despite many storms of unforeseen circumstances and constraints, we are still successfully sailing through and continue rebuilding glorious Bharat in a style, speed, and a design of our own. The provisions of our Constitution are not magic wands that can bring miraculous remedies to all our social ills and injustices of the past and present. They are not mathematical formulas having their essence in their form to provide quick fix solutions to long-term problems. They are indeed organic living institutions whose seedling transplanted but grown on our own soil of unique history, ethos, and values. Their growth through judicial interpretation and intervention is vital, not formal. At present, such growth is the need of the hour so as to translate our constitutional vision and dreams into reality and touch the future. We have to keep the constitutional path to social justice clear of all obstructions. We need to cut out the dead wood along the path from time to time and trim off the side branches that impede our path and vision. As we advance as a vibrant nation of youths, old order ought to change, yielding place to new, leading to new vistas. Ladies and gentlemen of the great profession, it is time for us to reflect and renew our unwavering commitment as sons and daughters of this great land to contribute, promote, and empower our new Bharat in the creation of an adequate and progressive social order which guarantees not only good governance, rule of law, fundamental human rights and freedoms to every citizen, but also food, clothing, shelter, education, health, and a steadily rising standard of living for all, especially for the poor, downtrodden, and the marginalized. Before I conclude, I would like to say what some of us may not like to hear, but nevertheless, it must be stated. We may have the best constitution in the world. Our constitutional vision could have been the most adorable one. We may have the highest pool of talents in the world after the United States of America. We may have all potential and more natural resources than many other developed countries in the world. But the ultimate success of our Constitution and realization of the Bharat dream primarily depends upon the quality of the people including the ones in the political arena, the actual performance of their constitutional and civic duties as law-abiding citizens, and their selfless role and contribution in nation building. To make the dream come true, every one of us, whichever part of India one belongs to, whether he or she is a vociferous urban university student or a jaundiced member of any vested interest groups in the guise of a student, challenging the very foundation of our democracy and our existence as a nation, security, unity, civility, and rule of law. Or one could even be a voiceless rural farmer from a remote corner of India. We all, irrespective of our position in the social or political hierarchy, require the highest degree of nationalism, loyalty, unity, integrity, social responsibility, and above all, a patriotic spirit that gives life force to the heart and soul of our nation. We, the right-thinking people of India, including the members of the legal and judicial community, cannot and should not continue to remain silent, indifferent, divided, and turn a blind eye to the ground realities, the disruptive forces of division, casteism, communalism, religious fanaticism, regionalism, linguicism, vandalism, hooliganism, terrorism, etc., and continue to lie lethargic for too long, while all such destructive isms are being indoctrinated, propagated, promoted to corrupt the minds of the vulnerable, and when crimes are instigated and perpetrated, sadly, in the deviant misnomer of freedom and democracy. To achieve Bharat dream, it is necessary to wake up and act in good time so that the unity, harmony, security, and integrity of India can be preserved by a spirit of common brotherhood, fraternity, mutual understanding, and respect for each other's rights and limitations. The exercise of one's rights is always subject to non-infringement of the rights of the others. There is a story that an Englishman walked along swinging his walking stick and it struck the nose of another person. When the injured person objected, the wielder of the stick said that England had ensured freedom to all people and that in swinging his stick, he was only exercising his right. The objector then coolly replied, I quote, "Sir, your freedom ends where my nose begins." It is truism that while in dictatorship, laws are enforced, in a democracy, laws are voluntarily observed. The rule of law in a democracy must be maintained by inner restraints and self-discipline, but maintained it must be at any cost. Without self-discipline, democracy loses its value and meaning. Let us own and share the responsibility for preserving the institution of democracy, rule of law, and good governance. Let us work together to build a glorious Bharat, which is economically strong, self-reliant, environmentally clean, free from the scourge of corruption, poverty, crime. Dear youths of India, dare to dream a glorious Bharat, which is leading in world trade and commerce, science and technology, breaking new grounds in innovation and creativity and more. We all should do whatever it takes and empower India to realize the Bharat dream, make this great land a better place to live in for everyone, and to secure the rightful place which it deserves in the new world order and in the emerging post-COVID-19 era. In the life of any nation, 70 years of independence is a period long enough for constitutional introspection reflection and stock taking to fine-tune and sharpen our vision. It is the need of the hour, brothers and sisters, that we ought to fine-tune the focus on our constitutional vision and sharpen the constitutional tools, if necessary, in order to meet the changing and challenging needs of our time and society, to preserve unity in diversity, to protect national security and territorial integrity. The time is now and here. All should awake, unite, arise, and stop not till the constitutional goals are reached and the Bharat dream is realized. Thank you all for listening to me and for your kind indulgence. May God bless India. Jai Hind.
Thank you, sir, for the wonderful session.
Thank you.
We are very enlightened to hear this view from you under the title Bharat. I would like to update all our friends here that, recently there was a petition in the Supreme Court, Nama versus Union of India. It was just decided on the 3rd of June, wherein the petitioner has petitioned to rename India as Bharat, where we get to see normally in the constitution, India, that is Bharat, which starts. So the Supreme Court has, ordered that the petition be converted into a representation and the necessary action be taken by the related ministry. So let us see that, let us hope that we see that day India is recognised as Bharat officially for all purposes. Thank you again. The session is open for interaction, and questions have been received, and a lot of people are asking questions. If we are, due to the paucity of time, we will be taking limited questions, and we have received some questions here.
Yes.
The principal, Dr. Mohan, he is a principal of the Law College in Bangalore. He is asking you, what should have been the rule of law specific to the migrant workers' welfare in the wake of this pandemic? If you can address this question, sir.
The migration workers, they all enjoy all fundamental human rights. So it is the duty of the government to respect the fundamental human rights guaranteed by the Constitution, irrespective of their movement within the territory, movement from state to state. When you say immigrant, migrants, it is misleading. I'm not able to understand whether immigrant.
Can you hear him, Mr. Gaidani?
Yes.
Technical. Immigrants means who are the immigrants? Have you defined who are the immigrants? The illegal immigrants from outside the territorial jurisdiction, or the immigrants from one state to another? So this is very unclear. Whatever be the interpretation given to the word immigration, as long as they are the citizens of India, they have the right to move from one place to another, from one state to another. So it is their fundamental right, and the government has to ensure and protect them and give necessary facilities for them to move from one place to another. Maybe they are moving towards their villages, their native place or native state, native town. I think they should be allowed, and the government should facilitate them to have that freedom, subject to, anyway, the public health issues. So in my view, the immigrants are no way inferior to any other citizen who is enjoying all the constitutional rights guaranteed by the Constitution. under Part 3rd. So they have the rights to move from one place to another, and it is the duty of the state to facilitate.
Like you have rightly mentioned in your session that we need to look into the provisions of the Constitution and alter them as to suit the requirement of the time. And Article 19(1)(g) takes care of this migrant issue, whereas allows everyone. Next question we have from Advocate Shri Rajiv Patil sir. He's asking, how do you distinguish between the legal systems in India and Seychelles?
Yes. Actually, I studied the common law, mostly the British laws. Seychelles was also a British colony once. So most of the legislations which they enacted in the English Parliament applied to all their colonies. So for instance, the criminal law, the Indian Penal Code, more or less word by word, we have the Seychelles Penal Code. So in all the former British colonies, we have the same laws. Maybe the section would be different. And Seychelles, since it was a French colony for some time initially, we still have the French influence, the jurisprudence, the French jurisprudence. For instance, the civil law. We have codified the civil law. That is Code Napoleon. That was a French code. That was translated into English and implemented in Seychelles during the British time. So in the civil side, for instance, the law of succession, law of contract, property matters, they all we inherited from the French. So still we have the mixed jurisprudence, French and English. Especially criminal procedure code, criminal law, basically company law, English law.
Okay.
Yes.
Next question.
Next question.
Yes. Mr. Target?
Sir.
Yes.
Yes. Hello, sir.
Yes, please.
It's a pleasure to meet you. And my question is to you. As you have chosen the words glorious Bharat instead of glorious India, so what is the difference and what will be the vision in the bird eye view of this global citizen, my lord?
No, I am not able to get your question. Can you please?
You have specifically
He's asking, you have titled the session as Glorious Bharat.
Yes.
So why did you particularly choose Glorious Bharat instead of the general parlance that we use, general Glorious India?
Yes. Why I chose this because
am I right, Mr. Target?
Yes. We were our glory. We had a very good past glory, glorious Bharat. So at least we should bring back those days. We were rich, and people from many other countries were looking for India. In those days, I'm talking about 1,000 years ago. Many people, they were looking up India for everything. Economy, commerce, trade, education, like Nalanda University, and there are so many education institutions, international institutions we had. So we lost our glory. We should bring back India to the past glorious state. So this is why I used the word glorious. We are not new to become glorious. We have been glorious, and we have to bring back that state. That's why I use the word glorious Bharat.
Sir, I have one query.
Now, just a minute. Now, my further question is to you, whether and what changes are needed in judicial system to make the Bharat glorious again or further?
Yeah, you see, the judicial system has a main role to play in changing the country. in every dimension. So the policy of the government has to be implemented only through the courts, the laws. Even though if you enact a particular legislation in the parliament, you have to finally go to court. Either they might declare it's unconstitutional or constitutional, whereby the final decision on any issue end up as a legal question and determined by the judiciary. That is why the courts always must be forward, one step ahead, and we cannot go back to those days, and we must advance with the rest of the world. Everything is advancing, everything is changing for the good. So we cannot remain on the, for instance, old precedents. Yes, we were certain policies after independence, and now we are moving in a different direction. And the courts should understand and interpret the laws in such a way it will lead to our development further. That's why judiciary has a main role for determining the future of India.
We have one question from Advocate Sri Ajay Toshniwal. He says, like the way we have medical council in Bharat, we have the bar council in Bharat, or of India rather. Do you think the parliament and the times now demand that we have a media council of Bharat, media council of India, to regulate the media and all the related professionals?
This is my personal view, but I think the professional bodies should function independently without any interference from outside. And the media commission cannot and should not put any pressure on any professional bodies. And when the bar council, if they have any issue, they themselves, they are the best people to determine how to resolve those issues, how to formulate policies, rather than outsiders come and tell what you should do, what you should not do, what should be your policy, and so on. I believe each medical profession should be given autonomy. They should determine their own decisions, whatever they take in respect of their practice or the rules or whatever. They should be allowed to function independently. And eventually, if there is something wrong, you have the right to challenge those things in courts. If any professional body, if make bylaws, regulations to govern their own bodies, and if there is any violation of the constitutional provision, you have the right. So there is a check. So they need not worry about that this can be misused if the autonomy is given to professional bodies, even medical, even legal. So I am of the view they should be given independence. There should not be any interference from any medical media commission or anything outside.
Okay. Thank you, sir. You mentioned about temporary provisions. You touched upon the issue of temporary provisions of like Article 370 and all.
Yes.
Just inquisitive. Some lawyer is asking, gentleman friend, I cannot see his name. He's saying Article 370. What is your take on it, first thing, and how do you see the question? Is there any provision of temporary provisions in the Constitution of Sessions? I mean, just inquisitive. This is my question to his addition.
Yes, when we move from one system to another, always there is a transitional period. We got independence in 1947, and then we are moving towards our sovereign state of our own. So during the transition, we had a lot of other issues to deal with. So without any transitional provisions, we cannot move forward and build a modern state. So in that process, of course, they needed to incorporate certain temporary provisions because there were some area, for instance, territories were problematic There were about 500 small kingdoms. And those days, it was not easy for even Patel to go and fight with some people. For instance, the Hyderabad Nizam, of course, he used force. And then finally, they agreed to accede to our to Indian Union. So when there is such a transition, you have to necessarily incorporate some transitional provisions to meet those needs. When the needs are met, then we can simply amend or repeal or remove those transitional provisions. I think this happens in every country.
Okay. But how do you see the situation after independence from the United Kingdom as the Republic of Seychelles and the Republic of India? How do you see the situations and how the nations have developed? How
Of course.
they have evolved?
Yes, they have developed tremendously. So during British time, of course, there were no developments. Whatever the developments they made, these were only for them to survive, to rule, to manage the country. But they were not interested in this country, in the development of the country. So now, after we got independence, even in Seychelles, in India, our development is tremendous.
Thank you, sir. Advocate Girish Naik Thigle from Aurangabad, he is asking, how do you see the contemporary development of federalism versus the unitary dominance with special reference to Indian Constitution?
No, I'm not able to get the question, please.
He is asking, how do you see the contemporary development of federalism versus unitary dominance with special reference to the Indian Constitution?
Yeah, you see, this is the beauty of Indian Constitution. You see, we are neither federal nor unitary. We are not unitary like the United Kingdom or as federal as the United States, because our conditions are unique. We cannot have a federal government like the states, and we cannot have the unitary government because we so much of diversity. And this our constitution is a combination of both. For instance, the concurrent list and the state list and the federal list. There is a fine balance that has been achieved in our constitution, unlike United Kingdom. For instance, the judicial review, the due process, what we call in the United States, you can challenge any legislation of the Congress or Senate. The court has the power to declare any law unconstitutional, the Supreme Court of the United States. For instance, in the UK, whatever the law passed by the Parliament, the judiciary has a limitation. The supremacy is with the Parliament, not with the judiciary. In India, it's fine balance. It's a fine balancing act. You know, sometimes you may think the sovereignty, the actual supremacy lies with the Parliament. At the same time, sometimes you feel that the supremacy is with the Supreme Court of India. So that balance is there. But the other countries, they have the extreme, the unitary constitution like the United Kingdom. We are not following that. At the same time, we are not as federal as the United States. This is a fine balance. I think this is the way we could survive with all these problems. Had there been more power given to the federal government, and could be it might lead to maybe other problems, divisions, and secessionist movement might come and so on. There are so many issues. Yes, Nilkant.
We have a very very emotional question coming in from Mr. Gaidani, the office bearer. He's asking,
yes.
Do you feel that we should have Supreme Court benches in the states, in the southern states?
Yes, I would agree. Yes, we must have at least one bench in the south, because accessibility to justice, even though we do not have in the Constitution, is a fundamental right. Accessibility means you can access the court, but doesn't mean that you can access from the south. For instance, if an Indian is from the southern part of India, wants to get justice, the final apex court, he cannot come to Delhi. It costs. I mean, it involves cost, time, and so many other constraints. So I think to give access for justice to all citizens, it is better to have a bench in the south. It's a big country. That's why we need decentralize or have another bench at least.
Yes, one gentleman, Mr. Chandrahas Hanekar, a good friend of mine, he's also suggesting we should have similar arrangement for the Northeast as well.
Northeast.
Supreme Court bench in the Northeast as well.
I mean, do you need a separate bench for
because the Northeast is also a region which is very difficult to access.
Too remote, yes.
Too remote.
The accessibility is a bit difficult for those who are living in the Northeast. Yes, I think it is better to have even a bench for the Northeast.
One more question coming in again, a quick question from Mr. Toshniwal, Ajay Toshniwal. He's asking, in the light of the recent developments, do you feel that the governor's discretion is required, should be properly regularized? I'm sorry. The governor's discretion should be properly regularized. The discretionary powers of the governor.
Yes.
What is your take on it?
Yes, when you say discretion, it's always dangerous because it depends on the individual who is given that power of discretion. When an executive, even though governor is an executive, when he takes any decision using his discretion, he should use it judicially, with a judicial mind, not as an administrative discretion. This discretion in certain areas given to the governor is quasi-judicial. So he has to apply the basic, the rules, the principles, adi altum partem, and so on. So there are certain areas where the governor has to use the discretion with caution as a judicial discretion, quasi-judicial discretion. This is maybe one that.
Sir, since you broke up the topic into quasi-judicial discretion and judicial discretion,
yes.
Just as part of academic interest, since you are not part of the Indian judiciary, recently we have seen the discretionary power of the judiciary in similar matters, which has been the case. I mean, they have taken different stands at different times. But as regards to clubbing of FIRs, multiple FIRs being filed against, say, Arnab Goswami. So there was a certain judgment which came in Arnab Goswami's matter. There was a similar matter which was filed, which was for Pankaj Punia. And then, if I remember, there's a similar matter which was filed by Sharjil Imam. All three decisions have, matters were same, but decisions have come out differently. I mean, just as part of academic interest and to discuss the powers of discretion, what is your take on it?
You see, precedents, law cannot remain stagnant. A year ago, the court might have taken a particular view on a particular issue. After 1 year or 2 years, a lot of things change. And sometimes we have to depart from the previous views. That is allowed. Otherwise, law will, stay stagnant. We must grow. So the growth shows that there will be departing judgments. So I think the court has its wisdom to apply the discretion accordingly. You have to look into various aspects of the case and the circumstances and the time in which that view is held by the court. So I think we cannot find fault with the court because in a previous case, they decided that way. This case, they have decided this way. Of course, precedents are useful, but this cannot be a obstacle, hindrance for our growth. So I think discretion sometimes differs, and we should cautiously use the discretion at different circumstances and different time.
Thank you, sir. There's one more question coming in. What is the difference and how favorable is the Republic of Seychelles as a tax haven as in comparison with other countries?
Yes. You see, in Seychelles, we encourage investors, FDIs, foreign direct investments. So if you come and invest, outsiders come and invest in Seychelles, we have 5 years tax holiday and no tax on any income derived from their business or investment in Seychelles. Likewise, you can import raw materials from outside to manufacture goods within Seychelles, and there will not be any duty or tax to be paid for the importation. There are so many, incentives given because we have to invite more and more investors from outside. So a lot of benefits. As far as tax is concerned, it is a company 35%, as I think even in India it's 35%. And on income, there is no other tax benefits for individuals other than what we have in India.
Okay. So one gentleman friend, Mr. Anekar, he is asking, Chandra Anekar, as a constitutional expert, what would be your suggestions as regards, what changes do you see needs to be made in the Indian Constitution to build up this image of the glorious Bharat?
It's a good question, but you see, let the circumstances decide what issues to be resolved. Certain issues now we face now in this decade. We never thought these issues will arise about 10 years back or 20 years back. So every now and then the judiciary should be active. I would say the judicial activism is very, very important. And when the politicians fail in their duties and the judiciary come in and try to set those failures right. even policy making. One party might come to power, which may take a different policy view, and another party might come, but it's the judiciary which is constant. That has to make sure that whatever the policy that particular government is bringing to implement, the judiciary should check whether this is in accordance with the constitution, whether this is violating any human rights, whether it lead to corruption, whether this is going to bring prosperity to the country. And there are many such issues that only when you go and challenge a particular legislation, particular act of the executive in the Supreme Court, they should take a proactive view and bring change. You cannot bring change within a day, but it's a slow process from precedent to precedent. So this is how the judiciary has a major role in transforming the country. It's socio-political. Yes.
Please.
Sir, I have a question.
Yes.
Just there's a continuing question.
Do you feel that socio-political pressure affects the judicial minds and decisions?
I cannot give a straight answer because different judges take different views on this issue. You know, after all, judges are human beings. They can say, I have no bias, I have no this, but anyway, they are all living in the same world where we live in. So we have our own bias, maybe within us. You know, just because we are a judge, you are a human being, first of all. And you have your own views that reflects in your judgments, in your decisions. So you do not know what type of background that judge comes from. Socio-political, economic situation, that has an influence, impact on the decisions he makes. So that depends on the individual. It's an individual choice.
So normally,
see, that's why, yes.
Normally we see a different, we hear a different speech, a farewell speech, even with the Supreme Court judges. A going speech is a different speech from all the other speeches the judge has given earlier.
Raju Patil sir, do you have any question in respect of this session? He is former chairman of Maharashtra and Goa Bar Council and learned senior advocate.
Raju Patil sir,
yes,
not visible.
Unmute him.
Yes, unmute.
Yes, sir.
Yes.
No, somebody was talking about the socio-economic pressures, no doubt about it. But the question is, when the judges say that, judges of the Supreme Court especially, when they see what's happening in the society, whether they should take note of it or they should ignore the exact situation and go by the letter of law.
No. You see, judges cannot simply sit on an ivory tower and close their eyes, saying that this is the law, I close my eyes, I apply the law. The judges should look at the society, what is happening in the society, how his decision is going to impact on the society. So judges should never think that they are living in an ivory tower and they have nothing to do with what is happening in society. So in my view, judges should see the end. The end is justice. The law is a means. What is more important is not that law. If you apply a strict letter of the law, if it leads to injustice, what's the purpose of having that law if it doesn't yield the result which is supposed to yield? So when there is such a situation, it is for duty of the judge to interpret the law in such a way it leads to justice. The strict application of the law, the strict letter of the law may lead to injustice. If that is the case, it is the duty of the judge to interpret it in such a way it reaches the end. The end is justice. So there are two types of judges. Some judges, as you said, no, my hands are tied. Even if glaring injustice is done in front of me, I have to apply the law. The law says this, so I strictly apply the law, whatever the consequence. So this type of judges on one category. There are other judges, they interpret the law in such a way their aim is to give justice. They won't stick to the letter of the law. But me personally, I never stick to this interpretation of law and try to interpret the law in such a way it leads to justice.
Sir, in continuation of my question, I'm just adding it that recently there was a kind of a migration problem in India because of the COVID-19. And there was a public interest litigation filed in the Supreme Court of India when the judges of the Supreme Court decided to go by the word or the statement made by the Solicitor General of India and did not take a notice of what exactly is happening on the street. What is your take as a judge of the Supreme Court that whether the Supreme Court judge should accept only the statement made by the state or should go by the actual situation on the street?
Yes, in my view, we cannot simply act upon the statement made from the bar. The judges should look at the big picture. What is happening in society? What is the degree of plight they undergo? The suffering. I think these are all, I can take this as a judicial notice. You need not act on evidence to establish certain facts. And the judges should not ignore those facts, which even though stated differently by the Solicitor General or the other lawyers in court, I think they should consider. But anyway, you can't, as a judge, go beyond the evidence, beyond the statements made in court by the counsel. At the same time, you must know how to do justice, how to get over those points, how to interpret it. I think judges can do that without offending or without deviating from the rule of law. They can do it.
Sir, my question is, some states become industrious populous, more populous because of industrial policy. And you can see the Maharashtra and Gujarat, where other workers of the other states are coming and staying here. And because of a lack of all India industrial policy and other subjects, these things are happening. And one of the reasons is outcome of these migrant workers. So do you feel that the industrial policy, land acquisition, land education, these all subjects should transfer from state list to union list or to creation of all India policy for industrial development and for land acquisition?
Yes, I agree with you on that issue. The industry is, mushrooming everywhere, without any regulation. A particular state take advantage, and most of the industries are concentrated. For instance, Mumbai, Maharashtra, it's a concentration of industries. I think this should be spread, fair distribution all over India.
Decentralized.
And in that respect, we need a federal interference. The central government should interfere and regulate. There should be some kind of board or commission that should formulate the policy. The states should follow those norms and policies, so that we should not have concentration of industries. It leads to many problems, not only immigration, pollution, and resources, for instance, the power, water. I mean, most of the industry, they take all the water and all the power, and then the citizens, they suffer. There is a shortage, scarcity of water and so on. So industries should be, I think we should regulate the location of the industries. I do not know whether they have such, there
is no all India policy on this.
We need all India policy.
And
yes, I agree with you.
Land is the subject matter of the state. So land acquisition proceeding is through only land state, it's going through the state. Also the education is also the state subject. So it becomes some part of this concurrent subject. Now these we need to change, and we should need to change, send this subject to the union list, shift to the subject to the union list. So we can have the all India policy towards this subject.
Anyway, that I have my doubts on that, because the state government should also have a say in that matters, because of the land, the scarcity of land and other resources. They should have a say in it. We giving the full autonomous power to the central government might lead to conflicts, regional conflicts. I think we should be very careful when we deal with, for instance, the land acquisition and various other concurrent list. If we try to take over, deprive the states from of their rights from the concurrent list, it might lead to some problems.
Then how we will manage all India policy?
On which subject?
Industrial policy, land, because land, industrial policy and education are correlated to each other.
Hello?
Can you hear?
The
Yes, I can hear.
industrial policy, land, industrial policy and education, these subjects are correlated to each other.
Yes.
So unless those subjects are properly regulated, we cannot formulate all India policy.
Yeah, but we cannot, I think it's not advisable to take over the entire power in respect of the land acquisition and the industries and so on, education. I believe they should have some kind of at least say in those decisions, unless the body is, the central body is has proper representation from the states, respective states. Sometimes it's
just
a very
like
sensitive
a GST
issue.
council.
Hello?
Just like a GST council.
Yes. Yes. Something like that, where you can balance the interest of the states as well as the common interest of the union,
We have one more question coming in. How do you see secularism has attained a new meaning altogether in the wake of the recent developments through the length and breadth of the country?
Yes,
what would be your position?
Yes.
How do we protect the secular fabric?
No, we are maintaining. Yes, I believe you are maintaining. Actually, we are maintaining secularism more than the West. For instance, in United States of America, they say we are very secular. We have separated the religion from the state. But still, you look at the bill, the dollar. It will say we believe in God.
Yeah, we believe.
So where is the secularism? There are people, atheists, they don't believe in God. And you claim that you are, but in India, we are more secular than the Western concept. We accept all religion. You know, we say the belief, faith and worship, we accept. You may believe that there is no God. We accept atheism. You accept anything. We are not talking, there is no religion, there's no word in the preamble religion. You can have any faith. You can have any belief. You can challenge the existence of God. Still, you have the liberty of thought, expression, belief, faith, and worship. So unlike Western has, we accept all religion, but in the Western concept of secularism is defective. They do not. Any atheist can say, I believe there is no God. Of course, you have the liberty of thought and expression and belief. So no religion. So our constitution is well balanced. I mean, secularism means we are not separating the religion from the state. We are inclusive of everything, not only religion, any faith, any belief. You may say, I'm non-religious. I do not believe in God. Yes, you are. That's your belief. You have the liberty of thought and expression and belief, faith and worship. That is covered. But in the West, you have to say, we reject all the religion. We are not religious. We do not allow the religion to come into the state. We separate it. That is hypocrisy. The actual secularism in our context is inclusive. We include everything. So that is why we have a fantastic constitution. Our secularism is one of the best concept, political thought imbibed in our constitution. We practice it, of course.
Sir, on this background,
yes.
Whether you will prefer uniform civil code?
Yes, I prefer uniform civil code. We have a uniform civil code here. In Seychelles, we have a uniform civil code, all codified. For instance, law of negligence, whatever, everything is codified.
Okay.
I think that there should be, there should be uniformity in law also. That is very, very important for national identity.
So how
there
do
should
you
be
how do you see the transition of Seychelles from the French hands to the British hands, and now as an independent country? How do you see the constitutional provisions and vis-a-vis the Indian constitution provisions?
No, we had, it got independence in 1976. After that, we had a constitution, a multi-party constitution. After 1 year, there was a coup. The government was dethroned, and then another party came in. It introduced one-party state. Seychelles was a one-party state for about 40 years.
Okay.
Now, of course, now the parliament is, opposition have majority in the parliament, but the president is a different type of system. President is directly elected. And the transition hasn't changed what we have inherited. Initially we were French colony, we have inherited French law in certain areas. Like civil code, we have civil code. This is nothing but French civil code, French code. French code is nothing but Code Napoleon. Napoleon was the ruler. He codified the civil law during his regime. So the France adopted that Napoleon Code, and it was a French code. Then French code was translated into English. They introduced that French code in Seychelles. When the British took over, they didn't disturb the culture, the language, the laws. What the French had maintained, they didn't disturb that. That's one best thing with the British. They will never change just for the sake of their territory. They may have a colony, but they didn't disturb. Even the name of the places, for instance, still we have all the French name. And in 1903, this became a British colony. Until now, they haven't disturbed the French laws, French names, French culture, and everything preserved.
Thank you, sir.
So this is the transition.
Could you enlighten the younger generation, the students, as regards what career options as lawyers do they have in Sessions?
Yes, Seychelles, you can work for the government Attorney General office. I see a lot of lawyers from India. They are working there, about 10 to 15 lawyers. But you cannot go private practice unless you acquire the citizenship of this country. But if you wish to apply, for a license to appear in a particular case, then the Chief Justice has the discretion. He will allow you a limited right of audience to appear in that particular case. If the client had retained you, we get a lot of lawyers from the UK, even from India, even from Delhi, case-to-case basis. They come and they practice, and until the final disposal of the case, the Chief Justice gives right of audience. Even if the case goes on appeal, he can come and appear. Only for that case. You cannot establish practice, public litigation practice here as a foreigner.
Thank you, sir. May I now request, if we are done with the questions, the office bearer, Joint Secretary, Mr. Targe, to express a vote of thanks.
Okay.
Mr. Targe.
I think there is some problem with Mr. Targe. He is not present.
Okay.
Yes.
Yes. I would like to special thanks our lecturer, Mr. Durai Karunakaran, for enlightening us on constitutional aspects. And I would also like to thank all participants, advocates, students who has actively participated in this webinar. All senior advocates, High Court advocates, all participants from the state of Maharashtra and all over India. Once again, I thanks one and all who has actively participated in this webinar. Thank you. Thank you very much.
Okay. Thank you very much, ladies and gentlemen. Thank you for your kind indulgence and for your time with me. And especially the special thanks go to Mr. Neelkanth. He was the one who first contacted me and organized this lecture. So thank you very much. We will keep in touch. I will be happy to come to you again on such event, and I will share on legal topics, specific legal topics, maybe in future. Thank you very much, gentlemen. Thank you very much, all the participants, for your time.
Thank you.
I'm so happy.
Thank you so
Thank
much.
you.
Thank you for
Thank you.
Thank you.
Namaste. Thank you.